The house always wins. How American Express built a merchant fee empire. In the gleaming towers of Manhattan's financial district, where trillion-dollar transactions flow like digital rivers, one company mastered the art of making money from money itself. American Express, the payment processing titan that began life as a freight forwarding company in 1850, had by 2010 transformed into something far more powerful and controversial, a merchant fee monopoly that would extract billions from small businesses while using anti-competitive practices to crush any threat to its dominance. For nearly a decade, from 2010 to 2018, Amex operated what regulators would later describe as a sophisticated scheme to maintain market control through exclusive dealing arrangements, anti-steering rules, and predatory pricing that violated fundamental antitrust principles. This is the story of how a payment processor became a financial predator, and how their own success ultimately led to their downfall. The foundation of American Express's controversial empire rested on a business model that was deceptively simple, yet devastatingly effective. Unlike traditional credit card networks that operated on what industry insiders call a four-party system, where banks issue cards and merchants have separate relationships with acquiring banks, American Express maintained a closed-loop system where they controlled every aspect of the transaction. This vertical integration meant that when a customer swiped an Amex card at a local restaurant or retail store, American Express collected fees from multiple sources: interchange fees from the merchant, annual fees from cardholders, and interest on outstanding balances. By 2010, these merchant discount rates, the fees charged to businesses for processing card transactions, had reached an average of 2.5% for American Express transactions, compared to 1.8% for Visa and MasterCard. This seemingly small difference represented billions in additional revenue, but more importantly, it revealed the extent of Amex's pricing power in a market where competition had been systematically eliminated. The company's internal documents, later revealed during federal investigations, showed executives celebrating their ability to maintain these premium rates despite growing merchant complaints, with one senior vice president writing in a 2011 email that their pricing strategy was designed to extract maximum value while merchants remained locked into accepting Amex cards due to competitive pressures. The cornerstone of American Express's anti-competitive strategy was a web of contractual restrictions that effectively prevented merchants from steering customers toward lower-cost payment methods. These anti-steering provisions, buried deep in merchant agreements that often exceeded 50 pages of dense legal language, prohibited businesses from offering discounts for using competing cards, displaying the true cost of different payment methods, or even suggesting that customers use cash or other alternatives. A typical Amex merchant agreement from 2012 contained no fewer than 47 different restrictions on how businesses could present payment options to customers, including clauses that required Amex to be displayed with equal prominence to other cards and prohibited merchants from expressing any preference for alternative payment methods. Small business owners across America found themselves trapped in what economists would later term a waterbed effect, where the high cost of accepting American Express cards was simply passed on to all customers through higher prices, regardless of their payment method choice. Internal Amex communications from 2013 revealed that company executives were fully aware of this dynamic, with one market research report noting that merchants were forced to raise prices by an average of 1.3% across all transactions to compensate for Amex's premium fees, effectively subsidizing rewards programs for affluent cardholders at the expense of cash-paying customers, who were often from lower-income demographics. The exclusive dealing arrangements that American Express negotiated with major merchants represented perhaps the most brazen aspect of their anti-competitive strategy. These sweetheart deals, worth hundreds of millions of dollars, were designed to prevent large retailers from dropping Amex acceptance or promoting competing payment methods to their customers. In 2014, American Express signed an exclusive partnership agreement with Costco, worth $3.4 billion over 7 years, which not only made Amex the only credit card accepted at Costco stores, but also included provisions that prevented the warehouse club from offering alternative payment incentives to members. Similar arrangements were negotiated with American Airlines, where Amex paid $2.8 billion to become the exclusive co-brand credit card partner, and with Delta Airlines, in a deal worth $4.2 billion that included clauses preventing the airline from steering passengers toward competing cards for purchases and upgrades. These exclusive arrangements created what antitrust experts call foreclosure effects, where competing payment processors were systematically denied access to high-volume merchant partners, making it impossible for them to achieve the scale necessary to offer competitive rates. Federal investigators later discovered that American Express had allocated over $12 billion between 2010 and 2016 specifically for these exclusive dealing payments, treating them as investments in market protection rather than legitimate business partnerships. The human cost of American Express's monopolistic practices became painfully clear when examining their impact on small businesses, the backbone of the American economy. A 2015 Federal Reserve study found that small retailers paid an average of $2,400 annually in additional fees due to Amex's premium pricing, money that could have otherwise been used for hiring, expansion, or improving customer service. For restaurants operating on razor-thin margins, typically between 3 to 5%, American Express fees represented a devastating burden that forced difficult choices between accepting Amex cards and maintaining profitability. Maria Rodriguez, who owned 3 family restaurants in Phoenix, testified before Congress in 2016 that Amex fees cost her business over $18,000 annually, equivalent to the salary of a part-time employee she couldn't afford to hire. Her testimony revealed that American Express had threatened to terminate her merchant agreement when she attempted to negotiate lower rates, leaving her with no choice but to absorb the costs or risk losing customers who expected to use their Amex cards. Internal American Express documents showed that the company specifically targeted small businesses for rate increases, knowing they lacked the negotiating power of large retailers and were unlikely to drop Amex acceptance due to customer expectations. One particularly damaging internal memo from 2014 described small merchants as price takers, who could be subjected to regular fee increases with minimal risk of defection. The regulatory response to American Express's anti-competitive practices began building momentum in 2012 when the Department of Justice launched a comprehensive investigation into the payment processing industry's business practices. Federal prosecutors, armed with subpoena power and whistleblower testimony, uncovered a pattern of behavior that violated multiple sections of the Sherman Antitrust Act, particularly provisions prohibiting monopolization and unreasonable restraints on trade. The government's case, filed in federal court in 2015, alleged that American Express had engaged in a systematic campaign to eliminate competition through exclusive dealing arrangements, anti-steering provisions, and predatory pricing designed to drive competitors from the market. Court documents revealed that Amex executives had explicitly discussed their strategy to maintain market dominance, with CEO Kenneth Chenault writing in a 2013 internal communication that the company's goal was to create insurmountable barriers for competitors while extracting maximum value from merchants who had no alternative but to accept Amex cards. The federal lawsuit sought not only monetary damages, but also structural changes to American Express's business model, including the elimination of anti-steering provisions and the termination of exclusive dealing arrangements that foreclosed competition. American Express's legal defense strategy revealed the sophisticated methods they had employed to disguise anti-competitive practices as legitimate business activities. Company attorneys argued that their premium fees were justified by superior customer service, enhanced fraud protection, and valuable card-holder demographics that provided merchants with access to affluent consumers. They claimed that anti-steering provisions were necessary to maintain brand integrity and prevent merchants from discriminating against Amex cardholders, while exclusive dealing arrangements were characterized as mutually beneficial partnerships that provided value to both parties. However, internal documents subpoenaed during the federal investigation painted a different picture, showing that American Express had conducted extensive economic modeling to determine the maximum fees they could charge before merchants would risk dropping Amex acceptance. A 2013 internal analysis revealed that the company had identified a pain threshold of 2.8% in merchant fees, beyond which even locked-in retailers might consider terminating their agreements, leading to carefully calibrated pricing strategies designed to extract maximum revenue while remaining just below this breaking point. Expert witnesses testified that Amex's claimed justifications for their practices were pretextual, noting that competing payment processors offered similar services at significantly lower costs, undermining arguments about the necessity of premium pricing. The financial scope of American Express's merchant fee monopoly was staggering, with company revenues from merchant fees growing from $8.4 billion in 2010 to $12.8 billion in 2017, representing a 52% increase during the period when anti-competitive practices were most aggressively implemented. This revenue growth far exceeded the expansion of transaction volume, indicating that Amex was successfully extracting higher fees per transaction through their monopolistic practices rather than simply processing more payments. Federal economists calculated that American Express had collected approximately $6.2 billion in monopoly rents between 2010 and 2016, representing fees above what would have been possible in a competitive market. These excess profits were largely redistributed to affluent cardholders through generous rewards programs, creating a regressive transfer system where small business owners and cash-paying customers effectively subsidized luxury travel benefits and cashback rewards for wealthy consumers. The irony was not lost on regulators that a company founded to serve merchants had become their greatest financial burden, with American Express extracting more in fees from small businesses than many paid in federal taxes. Internal company presentations showed executives celebrating record profits while acknowledging that merchant complaints about fees had reached critical levels, with customer service representatives instructed to deflect concerns rather than offer meaningful relief. The resolution of American Express's antitrust violations came through a combination of federal enforcement action and market pressure that ultimately forced the company to abandon many of their most egregious anti-competitive practices. In June 2018, the Supreme Court handed down a mixed decision in Ohio versus American Express Co. that, while allowing some anti-steering provisions to continue, significantly limited the scope of restrictions that Amex could impose on merchants. The court ruling opened the door for businesses to finally inform customers about the true cost of different payment methods and offer incentives for using lower-cost alternatives. More importantly, the decision created legal precedent that prevented American Express from retaliating against merchants who chose to educate customers about payment options, breaking the climate of fear that had kept businesses silent about excessive fees for nearly a decade. Concurrent with the legal proceedings, American Express faced increasing competitive pressure from new payment technologies, including mobile payment systems like Apple Pay and digital wallets that offered lower transaction costs and greater consumer convenience. The company's stock price reflected investor concerns about the sustainability of their fee-based model, declining 18% between 2017 and 2018 as analysts questioned whether Amex could maintain premium pricing in an increasingly competitive market. The American Express merchant fee scandal stands as a cautionary tale about the dangers of unchecked corporate power in essential infrastructure industries, where the line between legitimate business practices and anti-competitive behavior can become dangerously blurred. The company's systematic exploitation of small businesses through monopolistic pricing, exclusive dealing arrangements, and anti-steering provisions demonstrated how sophisticated corporations can manipulate market structures to extract excessive profits while avoiding regulatory scrutiny for extended periods. The ultimate cost was measured not just in the billions of dollars transferred from small businesses to corporate shareholders, but in the broader economic damage caused by reduced competition, innovation, and entrepreneurship in the payment processing sector. Today, as digital payment systems continue to evolve and new forms of financial technology emerge, The American Express case serves as a reminder that antitrust enforcement must keep pace with corporate innovation in market manipulation. The merchants who suffered under Amex's monopolistic practices for nearly a decade had limited recourse and minimal voice in a system designed to benefit payment processors at their expense. Their eventual victory in federal court represented not just a legal triumph, but a vindication of the fundamental principle that competitive markets, not corporate monopolies, should determine the price of essential business services in a free economy.